We are about to begin an exploration of one of the most challenging and legally complex true crime cases in modern Scottish history.
It's a story that's really centered on absence.
The absence of a body, the absence of a traditional crime scene, and of course, the profound absence of closure for a family.
We're examining a case where justice was achieved, but it was only after a decades-long legal marathon that really tested the integrity and procedures of the highest courts.
Our focus today is a meticulous examination of the source material surrounding the 1998 disappearance and subsequent murder conviction of Nat Fraser.
Right, for the killing of his estranged wife, Arlene Fraser. Our mission is to understand not just the crime, but the legal framework that was required to secure a conviction when the most fundamental piece of physical evidence, the victim's remains, was never ever found.
And we have to acknowledge that central tragic reality right from the start.
We do. Arlene Fraser's body was never recovered, and that fact defined every single step of this long, long journey.
Arlene Fraser, born in 1965 in Elgin, Scotland, she was a young mother, only 33 years old when she vanished from her home on April 28, 1998.
It was just after her two children had left for school.
And that date, April 28th, it just became this marker for a permanent and devastating loss.
It's so crucial to hold on to the human element here. The lack of closure about where her remains are has meant this long-standing, acute pain for her family.
Yes, that's the deeply sympathetic context that underlies all the cold legal procedures and court battles we're about to discuss. A life was taken, and the physical evidence of that act was, well, it was meticulously and ruthlessly concealed.
Let's begin at that moment, April 1998. When a person disappears without a trace, time is just absolutely critical.
So what was the initial assessment by Grampian police, and how quickly did that change? How long did it take for them to pivot from, a hopeful search to the much grimmer reality of a murder investigation?
Well, that pivot took about 6 months.
6 months.
Which, in the context of an investigation like this, is a significant amount of time, though it's maybe understandable given the circumstances.
So they started with standard protocol.
Exactly. Initially, police treated Arlene's vanishing as a missing persons case. They had to account for all sorts of possibilities, from her leaving voluntarily to, of course, foul play.
But by October 1998, things had changed.
They had. By then, the accumulation of circumstantial evidence and just the complete lack of any sign of life forced the investigative team's hand.
And who made that definitive declaration? Because that statement, moving from missing person to probable murder, that changes everything, doesn't it? The resources, the focus of the inquiry.
It was Detective Chief Inspector Peter Simpson. He made the formal public announcement in October 1998, declaring the conclusion that the investigation had reached.
And it was a very strong statement.
It was a critical turning point. He said, and I'm quoting here, "The only conclusion that's still left open to us is that something criminal has taken place here and that Arlene has been the victim of a crime. I am of the opinion that she's dead."
Wow. He went on to say, there's no indication that she's living somewhere else. And that declaration, it essentially retroactively turned the missing persons file into a homicide file.
But without any of the evidence you'd normally have.
Precisely. No corresponding physical evidence that usually kicks off a murder case.
So this transition immediately placed the investigative team in a tremendously difficult position. They had this certainty of a murder, but absolutely none of the traditional starting points.
Nobody.
No crime scene, and therefore no definitive forensic evidence pointing to how or when she died.
Exactly. They were effectively trying to construct a house without a foundation. Any typical murder investigation begins with locating the body, securing the crime scene. That dictates everything: the timeline, evidence collection, cause of death.
Grampian police had none of that.
None of it. The deliberate concealment meant they had to rely on this painstaking reconstruction of events, of movements, and most importantly, they had to build a case based on relationships, on motive, and this complex web of circumstantial evidence.
And the scale of it was huge. It's worth noting, yes, the Grampian police themselves later described it as the largest investigation they had ever carried out up to that point. That really speaks volumes about the difficulty and the resources they poured into solving this.
And crucially, the husband, Nat Fraser, he wasn't just some ordinary person being questioned. He was already deeply enmeshed in legal trouble, directly related to Arlene.
Yes, that underlying shadow is a massive piece of the puzzle.
What was that pre-existing legal shadow hanging over him?
At the exact moment Arlene disappeared in April 1998, Nat Fraser was out on bail. And this bail was granted in connection with a prior incident where he was charged with the attempted murder of Arlene.
Attempted murder. That fact immediately colors the police's perspective and provides a very clear, if circumstantial, motive.
It does. And it's interesting, as you said, despite that very serious charge, the police were initially satisfied with his alibi for the day she vanished.
They couldn't break it.
Or at least they couldn't dismantle it right away, and that alibi becomes a central pillar of his defense later on.
But that original charge, the attempted murder, it didn't just go away.
No, it was later reduced to assault, but it still resulted in a conviction. Nearly 2 years later, in March of 2000, Fraser was sentenced to 18 months in jail for that assault.
So you have the lead suspect in a high-profile murder inquiry, and at the same time he's dealing with the very real consequences of violence against his wife, the victim, in the years leading up to her disappearance.
It established a pattern of discord and intimidation that was highly relevant to the prosecution's theory of motive.
So to sum up the immediate aftermath, you've got investigators under immense pressure, a lack of physical evidence. They're forced to build a case on these complex circumstantial threads.
All while the primary suspect is already dealing with serious convictions related to violence against the victim.
The difficulty of that position-proving murder when the victim and the scene are gone, it can't be overstated.
It really can't. It forces the investigation to find the human link, the person who knew what happened and, perhaps more importantly, who helped cover it all up.
So moving on from the initial disappearance, the investigation quickly realized that solving the murder meant unraveling a conspiracy.
Yes.
And the sources make it clear that the charges drew beyond just the killing itself, to include actions taken to mislead the police. This is where we see that key Scottish legal concept of perverting the course of justice. What does that charge actually imply? How did it expand the scope of the case?
That's a critical distinction in Scots law. The charge of perverting the course of justice is applied when an individual takes deliberate, affirmative action to cover up a crime, obstruct an inquiry, or knowingly mislead investigators or the court.
So it's not about the murder itself.
No, it's about the subsequent attempts to ensure the perpetrators get away with it.
And this concept was essential here, wasn't it?
It was. It allowed police to charge individuals for the cover-up efforts, even if they couldn't immediately prove they committed the murder. It showed premeditation not just in the killing, but in the calculated disposal of evidence.
And what was the central piece of physical evidence that tied this whole cover-up conspiracy together?
The central thread was a vehicle, a beige Ford Fiesta.
The Fiesta.
Investigators became convinced this car played a direct role in Arlene's disappearance, or more likely, in the transport and disposal of her body.
And this is what led to the charges.
Yes, Nat Fraser was charged with perverting the course of justice related to inquiries about this specific car, and so was his friend, Hector Dick. This marks the moment the case becomes explicitly about a group conspiracy.
Let's focus on Hector Dick. He quickly became a critical, though, a highly unreliable figure.
Extremely.
His own trial on these charges had to be moved and delayed. When his proceedings finally started in 2001, what was the outcome for him at that early stage?
The initial proceedings involving Dick were very dynamic, and they really set the stage for his later, much more significant role. In early 2001, on the 4th day of his trial for the cover-up charges, Dick unexpectedly changed his plea.
He pleaded guilty.
He pleaded guilty to a slightly lesser charge, yes, essentially admitting he helped cover up evidence, and he received a 1-year jail sentence.
That's a significant admission, even if it's not for murder. And the sources point to the tremendous personal pressure he was under while he was in jail.
Absolutely. The sources provide a profoundly sobering detail here. While he was serving that 1-year sentence, Dick attempted to commit suicide by hanging himself.
Wow.
And regardless of his specific involvement in the murder, that incident strongly suggests the immense psychological burden and the weight of the secrets he was carrying. He was under pressure not just from the law, but clearly from his conscience or his fear.
And that context is so important when we evaluate his later testimony.
It is, because as we'll see, it became the cornerstone of the entire murder prosecution.
It's easy to focus on the murder inquiry, but we have to remember that while all this was happening, Nat Fraser was still cycling in and out of court on completely separate charges.
Right.
He was released after serving half of his assault sentence in April 2001, but his brushes with the law were far from over.
Fraser's capacity to stay in trouble with the legal system is astounding. Just 4 months after his release in April 2001, he was jailed again.
For what?
This time for admitting to fraud, specifically for lying to receive nearly £19,000 in legal aid funding.
So even as the murder investigation is reaching its climax, the main suspect is continually proving himself to be a man willing to disregard the law for personal gain.
It reinforced a pattern of dishonesty that the prosecution would later capitalize on.
The conspiracy web also widened to include a third man, Glenn Lucas, who was charged in June 2001.
Yes, for perverting the course of justice. That rounded out the initial group of defendants.
So all these peripheral charges were building the scaffolding for the ultimate legal confrontation. When did the Crown Office finally bring the full weight of the murder indictment against all three men?
It took nearly 4 years after Arlene vanished.
4 years.
Until April 26, 2002. At that time, the Crown Office announced the final comprehensive indictment. Fraser, Dick, and Lucas were all formally charged with conspiring to murder Arlene Fraser, the murder itself, and attempting to defeat the ends of justice.
And that indictment marked the formal transition of the case from this long-running, complex police investigation into a high-stakes courtroom drama.
And the first trial, which kicked off in January 2003, saw this dramatic, high-risk, strategic maneuver by the prosecution, a move that just fundamentally changed the trajectory of the proceedings.
Okay, this is where it gets really interesting. The Crown had indicted 3 men, Fraser, Dick, and Lucas. So what was this massive strategic pivot that the prosecution, led by Advocates Depute Alan Turnbull, QC, decided to make mid-trial?
They made the decision to drop all charges against both Hector Dick and Glenn Lucas.
Both of them.
Both of them. But this was not some move of simple leniency. It was a calculated, tactical decision to transform a co-defendant, Hector Dick, into their star witness.
Their star witness.
Turnbull QC announced that Dick would now be called as a witness against Nat Fraser. This meant the man who had pleaded guilty to covering up evidence was now being presented as the source of the truth regarding the murder itself.
That seems like an almost impossible gambit. Using a confessed perjurer and evidence concealer as your key witness in a murder case without a body. How did the defense not immediately cry foul?
Oh, they did, in essence, but the legal system had to adapt. The trial had to be immediately adjourned because of this switch.
Why?
Procedurally, Fraser's defense team now had a fundamental right to interview Dick and Lucas. As co-defendants, they had the right to silence, they were inaccessible. Once the charges were dropped, they became available witnesses, and the defense needed time to prepare.
To adjust their entire strategy.
To adjust their entire strategy to this devastating new development, the adjournment was vital to ensure Fraser's right to a fair trial was maintained.
So when the trial resumed, the prosecution was essentially gambling their entire case on Hector Dick's credibility.
Completely. Since they lacked a body or forensic proof, his testimony had to be powerful enough to close all the remaining gaps.
And what specifically did Dick tell the court that provided that missing link?
Dick's evidence was simultaneously damning, gruesome, and utterly crucial. First, he admitted to his own criminal actions. He confessed to burning and crushing the beige Ford Fiesta precisely because he feared it would link Fraser to Arlene's disappearance.
So he confirmed the act of cover-up.
He did. But the most explosive part was his account of what Nat Fraser allegedly told him about the disposal of the body. Dick claimed Fraser told him he had arranged for his estranged wife to be killed.
Okay.
And subsequently disposed of her body by the chilling method of grinding it up and burying it.
Let's pause on that quote, grinding it up. In a trial with no body, that specific, horrific detail becomes functionally essential for the prosecution, doesn't it? Why is that so important?
Because without that testimony, the defense could maintain the plausible doubt that Arlene had simply run away, or that her body was somewhere it hadn't been searched, or even that Nat Fraser wasn't involved in the actual disposal.
It closes the loop.
It closes the loophole. The prosecution needed to definitively explain the permanent, total absence of remains. Dick's, quote, provided that explanation: complete and irreversible destruction. By explaining how the body was disposed of with ruthless efficiency, it eliminated the reasonable possibility of survival or accidental disappearance.
Allowing the jury to conclude beyond reasonable doubt that a murder had occurred and Nat Fraser orchestrated it.
Exactly. This testimony was the bedrock upon which the entire conviction without a body rested.
So on one side, you have the prosecution relying on this shocking secondhand testimony from a highly compromised individual who confessed to destroying physical evidence. What was Nat Fraser's defense against this?
Fraser lodged a special defensive alibi. He claimed he was physically elsewhere, specifically performing deliveries for his fruit and vegetable business on the key date Arlene vanished.
And he had a witness.
He had an employee testify on his behalf, corroborating his movements on that day. The defense strategy was simple. If I was demonstrably elsewhere during the window she disappeared, I couldn't have committed the crime. They sought to inject reasonable doubt by balancing this alibi against the prosecution's circumstantial web.
The jury was faced with a massive conflict. A corroborated alibi versus overwhelming motive, destruction of evidence, and that secondhand testimony. What did they conclude?
On January 29, 2003, after considering all the evidence, the jury found Nat Fraser guilty of the murder of his wife, with others unknown.
So the conviction was secured solely on the strength of this circumstantial evidence and witness testimony.
Proving that a conviction for murder is absolutely possible under Scots law, even when the body is successfully concealed.
And the judge, Lord Mackay, was clear in his condemnation. What was the sentence, and what did he have to say?
Lord Mackay sentenced Fraser, who was 44 at the time, to life imprisonment, recommending a minimum term of 25 years.
25 years.
And he described Fraser as evil before passing the sentence. It was a moment of high drama. Fraser actually collapsed in the courtroom upon hearing the verdict.
The severity of the sentence reflected the judge's view of the premeditation and brutality required.
It did, and that concluded the first act. But as we know, the legal battle was only just beginning.
A conviction of this magnitude, based entirely on circumstantial evidence and, disputed testimony, was always going to face a strenuous appeal process.
Of course. Fraser's defense team immediately signaled their intention to fight. And this case quickly escalated and became a landmark example of legal controversy.
It truly became a benchmark case for procedural integrity, didn't it?
It did. Fraser lodged his appeal in December 2003, and leave was granted in May 2004. For the next few years, the appeal just ground its way through the Scottish system.
But then the public conversation took a sharp turn in October 2005.
Yes, when a BBC broadcast specifically claimed that Hector Dick had lied during the first trial.
And this wasn't just media speculation.
No, it focused public attention sharply on the reliability of the man who was the cornerstone of the Crown's case.
This media scrutiny then led to a full-blown institutional crisis in 2006 regarding the fairness of that initial trial. What was the definitive, serious revelation that emerged?
The revelation was severe. It struck at the very heart of the defense's ability to conduct a fair cross-examination. It was discovered that relevant evidence information that should have been provided to the defense before the trial had been withheld.
A disclosure failure.
Yes. The Lord Advocate, Colin Boyd, was forced to make a public statement, calling the non-disclosure of this information to Fraser's lawyers a matter of serious concern.
This isn't a minor oversight. This fundamentally impairs the defense's ability to challenge the prosecution's narrative or the credibility of key witnesses, like Hector Dick.
Exactly. And this revelation of non-disclosure triggered investigations into the very structure of the Scottish justice system.
So what were the institutional responses to this failure?
The response highlighted the seriousness of the breach. 2 separate official inquiries were immediately launched. The Crown Office commissioned an investigation into exactly why the prosecution failed to disclose the evidence.
And the police.
At the same time, Grampian Police requested that the Association of Chief Police Officers in Scotland investigate their handling of the evidence, with Strathclyde Police leading that inquiry.
So this failure was recognized as potentially pervasive, requiring simultaneous internal investigations across both the police and the prosecuting authority.
That's right.
Meanwhile, the legal status of Nat Fraser became incredibly volatile, swinging like a pendulum. He was briefly released from prison, wasn't he?
Yes. In May 2006, due to the serious questions raised by the withheld evidence, Fraser was released pending the outcome of his appeal.
Just think about the chaos this created. A convicted murderer, sentenced to a minimum of 25 years, was walking free purely because of a procedural error by the prosecution.
But his freedom was temporary. After further allegations and significant distress voiced by Arlene's family, who demanded he be returned to prison, Fraser was taken back into custody in December 2007.
And despite the damning evidence of this disclosure failure, the Court of Criminal Appeal initially upheld the conviction in 2008. How was that possible?
In May 2008, the court refused the appeal. Their reasoning often focuses on whether, even with the withheld evidence, the jury would have likely reached the same verdict. Essentially, the Scottish Appeal Court found that the evidence, even if it had been disclosed, would not have fundamentally changed the outcome.
And Fraser vowed to keep fighting.
He did. He said, "The fight will go on, as will the fight to get to the truth." This decision forced him to seek an extraordinary level of legal recourse outside the standard Scottish system.
And this is where we see his legal tenacity really shine. He appealed to the Privy Council, which was refused. He lodged another appeal based on human rights legislation, also refused. So having exhausted all internal Scottish routes, he turned to the Supreme Court in London.
The Supreme Court, as the highest court in the UK, often acts as a constitutional and human rights backstop.
So they were willing to take it on.
They granted special leave, yes. His appeal to them was focused not on the facts of the murder, but purely on the procedure of the first trial, arguing the non-disclosure rendered his trial fundamentally unsafe and therefore a human rights violation.
And the result of that appeal in May 2011 was massive. He won.
Unanimously. The Supreme Court judges were unanimous in allowing the appeal. They recognized the procedural irregularity as so significant, so egregious, that it fatally undermined the safety of the 2003 conviction.
It established a crucial precedent.
It did. That the pursuit of justice cannot override the defense's fundamental right to review all relevant evidence.
And their ruling was very specific about the next steps. They used the legal term, remitted the case. What does that mean for the average listener?
When a higher court remits a case, it means they're sending it back down to a lower court for a specific action. In this instance, they sent it to a differently constituted appeal court to officially quash the conviction.
Meaning it was nullified.
Nullified, yes. And crucially, they also authorized that court to consider allowing a new prosecution.
And the Crown Office immediately stated its intent to seek fresh proceedings.
They did. This was a necessary but painful development for Arlene Fraser's family, who called the reversal bitterly disappointing, but accepted the necessity of the legal process continuing.
So the entire saga proved that the standards of disclosure are non-negotiable, even if it meant going through the trauma of a murder trial all over again.
The prospect of prosecuting a defendant for the same murder twice, particularly after the highest court in the land has quashed the first conviction due to procedural failures, is incredibly rare.
And immensely high stakes.
Immensely. The Crown had to be absolutely flawless in its presentation this time, knowing that the entire world was watching for any further missteps.
So the second trial started in 2012 in the High Court in Edinburgh, led by Advocate Depute Alex Prentice QC. For the prosecution, the core challenge was exactly the same, wasn't it?
It was. They had to prove murder without a body, and they had to rely once again on that central, controversial figure, Hector Dick.
The tension in that courtroom must have been palpable.
You can only imagine. Hector Dick was forced to repeat his highly sensational testimony, including the account of Fraser detailing how he disposed of Arlene's body by grinding it up. The jury had to decide, again, whether this secondhand, horrific account from a man who admitted covering up evidence was credible enough.
So how did the defense team, led by John Scott QC, approach this second trial?
Yeah.
They had the benefit of the Supreme Court ruling, full access to all the previously withheld evidence. They could run a much stronger, more informed defense.
And the defense was far more aggressive and targeted. John Scott QC argued robustly that the Crown's entire case was blighted by hindsight and assumption, suggesting investigators were so focused on Fraser from the start that they ignored other possibilities.
He called the evidence unreliable.
He did. But the most direct and crucial tactical move was during the cross-examination of Hector Dick. Scott didn't just question Dick's reliability. He suggested, directly and pointedly, that Dick himself had been responsible for the murder of Arlene Fraser.
That is the ultimate defense, counterpunch shifting the blame entirely onto the prosecution's star witness. What was Dick's response?
Dick vehemently denied the allegation. But the fact that the defense made that accusation on the record during a murder trial, it just demonstrates the extent to which they felt they could undermine his credibility.
They were asking the jury to choose. Believe the man who admitted destroying the evidence, or believe the accused who maintained his innocence and alibi.
That was the choice.
And the jury, after months of testimony, returned its verdict on May 30, 2012, almost a decade after the first trial. What was the final verdict?
Nat Fraser was again found guilty of Arlene's murder,
Again.
this time by a majority verdict. The legal system, after being tested through the Supreme Court and forced to correct its procedural failures, reached the same conclusion.
And the sentence?
He was sentenced to a minimum of 17 years imprisonment. The fact that the conviction was repeated, even with a flawless procedure this time, it really cemented the judicial system's belief in the overall strength of the case.
Lord Brackedale's summation following that second verdict is incredibly powerful. It's a definitive statement about the court's view of the crime. What were the key elements of his address?
Lord Brackadale used his address to emphasize the chilling calculation and brutality involved. He told Fraser the evidence proved that he had arranged for someone to kill his wife and dispose of her body.
He called it premeditated murder in cold blood.
He did, stressing that it was the murder of your wife and mother of your children, who were just 10 and 5 years old at the time. He recognized the immense emotional trauma caused by this premeditation.
And the absence of the body was central not just to the trial, but to the judge's commentary on the cruelty of the crime itself.
Absolutely. Lord Bracondale highlighted that the body disposal was carried out with ruthless efficiency, for there is not a trace of Arlene Fraser from that day to this.
And he said this left her family bereft.
He did. And this is a crucial aspect of this type of murder conviction. The act of concealment becomes an aggravating factor. It ensures the maximum possible level of sustained cruelty to the victim's family, who are denied the fundamental human right of mourning at a grave.
The judge clearly saw the efficiency of the cover-up as compounding the evil of the crime itself.
Without a doubt.
With the second conviction secured, one might hope the legal road had finally ended, but Fraser's legal team still attempted a final appeal.
They did. Fraser's final appeal against the 2012 conviction was lodged and then decisively refused in October 2013.
And that was it.
The sources confirm that after this refusal, there were no further reported legal routes available to him within the UK system. The legal battle that began with a missing persons report in 1998
escalated through a quash conviction, 2 trials, multiple high court appeals.
It finally concluded more than 15 years later.
And while the legal process was so drawn out, the second trial itself became the subject of intense public scrutiny through a documentary, offering people an unprecedented view into the justice system.
That's right. The highly sensitive proceedings of the second trial were documented and eventually released as the television documentary, The Murder Trial. It aired on Channel 4 on July 9th, 2013.
And the significance of this documentary can't be overstated, can it?
It really can't, particularly in the context of British jurisprudence. It was only the second time that footage from a British murder trial had ever been broadcast on television. It offered the public this transparent, unfiltered look at how a high-stakes, circumstantial case is argued and decided.
And it was a huge critical success.
It was. It won the BAFTA for Best Single Documentary in 2014.
From a broader legal and historical perspective, the Arlene Fraser case has secured a definite, if infamous, legacy. How do legal scholars view this case now in terms of its lasting impact?
Well, the Arlene Fraser case is consistently referenced globally when discussing successful prosecutions of murder convictions without a body, and it's listed among solved missing person cases. Its legal legacy really rests on 2 pillars.
Okay, what's the first one?
First, it showed the functional power of circumstantial evidence and witness testimony, specifically Hector Dick's account, in overcoming the immense challenge posed by the complete absence of forensic proof. It demonstrated that a jury, when presented with a plausible mechanism of disposal, can convict.
And the second pillar, which perhaps had the greater influence on subsequent legal practice, was that issue of disclosure failure in the first trial.
Absolutely. The lengthy appeal process, culminating in that unanimous Supreme Court reversal in 2011, forced a fundamental reckoning with disclosure procedures within the Scottish legal system. That ruling demonstrated that a verdict, no matter how apparently correct, cannot stand if the basic procedural human rights of the defendant were violated.
So even though the final outcome of the second trial was the same as the first,
the entire saga established stricter, higher standards for judicial transparency and procedural fairness across Scotland. It proved that procedural justice is not secondary to the desire for a conviction.
the sources surrounding this case lead us through a protracted and painful journey. It ultimately confirms a premeditated crime executed with what the presiding judge called ruthless efficiency, ensuring Arlene's family would never have the comfort of a grave or closure on where she lies.
And that is the tragedy that remains the most powerful aspect of this case. It illustrates the profound difficulty of achieving justice when intent, disposal, and method are deliberately and thoroughly concealed. The tenacity required by the police and the Crown, coupled with the systemic pressure on the courts to re-examine proceedings through the lens of human rights legislation, it just highlights the tension inherent in our legal system.
The pursuit of the truth must always be balanced against the obligation to uphold the strictest standards of fairness for the accused.
Exactly. The Arlene Fraser case remains a powerful illustration of legal complexity meeting human cruelty.
We appreciate you joining us for this thorough analysis of the sources surrounding the tragic events of 1998. Thanks for listening.